Hello, attorney Christopher Goodson here. Landlord-tenant is a very small part of my legal practice, but something interesting happened today. Now, landlord-tenant is usually pretty boring, but today we went in front of the judge on a commercial landlord-tenant matter. And the issue was the following. I represented a large commercial landlord, and they had rented out a space to somebody who was using the first floor as a day spa. Now, this is in Hudson County. I won't be specific about the town, but the town had an ordinance that specified that you could not have a massage parlor. So, without knowing this, the tenant built out this commercial space, spent $40,000, they claim, on making this a massage parlor. Now, 6 months later, the landlord and tenant are fighting because the tenant can't get a certificate of occupancy, and they haven't paid the landlord in the last 6 months. So now the question becomes, whose responsibility was it to determine whether or not the spot could, whether the lease itself was valid? The argument from my opposing counsel is that they couldn't have quiet enjoyment of the spot. And they said that the purpose was an illegal use, and therefore the tenant should get paid 6 months rent. Now, for basement apartments, illegal apartments, that's the law. 6 months rent, back payment of the rent in order to get that tenant out. So they was trying to use that law in order to apply to the commercial. And I said, Your Honor, it's not that the space cannot be used. It's that it can't be used for a specific purpose restricted by the municipality. It's not like you couldn't use it for an accounting office or a law office or a tax office. The fact that they wanted to use this for a massage parlor meant that it was their responsibility to check it out with the city. The opposing counsel argued that because the lease said day spa, that we had made this false representation about the use of the property. So finally, I made the argument that if marijuana became legal in the state of New Jersey, and you wanted to rent a commercial space from me, that it would be you as the tenant's responsibility to check with the city itself to see, even though the marijuana sales were legal in the state, make sure that it was legal in that particular location, in that particular town. And the judge agreed. So it is generally, according to this one judge's ruling, the tenant's responsibility, but to avoid this in the future, I'm adding a provision to all of my commercial leases that simply says that the tenant is responsible for determining the legality of the particular use intended for the commercial space. So even though the judge ruled in our favor, adding a couple of lines would have saved a lot of headaches and a lot of hassle back and forth between the attorneys in order to get this commercial space rented. Good news is I got the vacate motion and the tenant is leaving and my client's very happy, but we could have done this a lot faster and easier if whoever drafted that lease had added in just a couple more lines. So for all my commercial landlord tenants out there, landlord clients out there, make sure you include those provisions or reach out to me and I'd be glad to help you draft them. Christopher Goodson, anything I can ever do for you, please let me know. Thanks.